wants somebody different on the eve of trial. Is that what I'm hearing?
Well, Judge, I think it might be. I haven't had an in-depth discussion about this with Mr. Powe. I know that Mr. Jordan Law filed with parents.
Well, it's hard to file a notice of appearance when he's got counsel and I haven't released you. So that's why I've done what I've done, and I don't mean to be animated about it. Please don't misunderstand. I intend to give Mr. Powe every right he's entitled to and to protect the rights he has. But I also desire to keep this case on track for trial, given the fact that we've worked hard to get here. So if there's case law that either side wants me to consider regarding my discretion in this matter, I will be happy to look at it. But my inclination is to recognize existing counsel and to say to Mr. Jordan, you shouldn't take a case where you've got a conflict with another trial, but that's entirely up to you. My expectation is you'll be here for this one in the event it's not continued. And I don't mean to be difficult about it. It's you put the court in a difficult place and you put the state in a difficult place and the people of the state of Florida who are also entitled to their trial. So with all of that said, I'm prepared to pass the matter and allow the lawyers to provide me with case law in support of their position regarding the substitution of counsel. And I'm going to recognize and protect every right Mr. Powe has. But to the extent the court can exercise discretion, I'm going to, and I'm going to keep the case on track for trial.
Judge, I did not understand before speaking with Mr. Murphy, Mr. Powe, and the state that Your Honor had, set this for, the August trial date with no continuances permitted. I didn't.
No continuances are permitted. If you give me good cause, I will certainly recognize it. And if Mr. Powe is entitled to counsel, and it's an abuse of discretion for me to require Mr. Murphy to remain in the case, then I'm going to defer to what the law requires. I'll find good cause. I'll give you the continuance you need.
Your Honor, if I may, and I didn't come with this because I wasn't anticipating that we would have a particular discussion, but I'm not ready to try.
So you have filed a motion for continuance.
I'm not, Your Honor, and I will. I was going to actually, and then Mr. Jordan Law came on, and I just did not. And frankly, Your Honor, I just assumed that they were going to give it a case. Otherwise, I would have actually.
State, do you need to be heard on any of these issues before I look back to Mr. Murphy?
Judge, I was aware that Mr. Murphy was telling me that he was not prepared and he was going to file a motion for a continuance. And prior to him doing that, then I had received this notice of substitution of counsel. Just to let the court know, and I have been very upfront with both Mr. Murphy and potentially this new attorney, if the court does continue this case because of all the cases and juvenile resentencings I have set, the earliest I can put it back on my calendar is either the last week in November or any week in December, because I am just booked solid right now unless something goes away.
I understand. Everyone is jammed with trial work in light of circumstances, including the court.
So other than that, I would defer to the court. I have been in contact with the victim's mother who is in court. She understands there's the possibility of a continuance.
In the event it's continued, at Mr. Murphy's request, it makes it much more likely that I'll approve the substitution of counsel. So let me look to defense counsel. Are you making an oral motion at this time?
Yes, sir.
And what's the basis for the motion?
We're not prepared.
In what sense? What's left? What remains to be done that is undone?
In particular, there are gang experts that said I was in the process of preparing some motions for it. And it was depositions. They were. That's one of the later witness lists that was provided by the state.
Has the state charged the gang enhancement?
We did from the very beginning.
I beg your pardon. Go ahead. And so that's the remaining detail.
That's the major detail. I think there might be, and again, I apologize for preparing this argument before he came in. But that in particular is a major point.
Is that the only remaining detail, at least from your perspective? New counsel may take a different track. What's going to happen is he's going to get all the discovery and he's going to review every deposition taken in the case and perhaps come up with a different theory of the case and a different defense of the case, and off we go, which is his right. Is there a reason why this wasn't ferreted out, given the fact that the state has represented this has been pending since the initial information? Have you actually identified potential experts who would testify on your client's behalf, or is this a theory you have not actually explored?
No.
You have not identified experts that would support whatever theory you currently have.
I don't have any experts.
Let me rephrase it. You've just indicated you're exploring the possibility of experts regarding the gang enhancement, and that's the remaining detail that needs to be resolved.
And Judge, if I may, I believe what he's referring to is in other cases in this jurisdiction where we have alleged a gang enhancement and we did list experts, there have been certain motions filed, certain hearings held, and that has not been done in this case. So I am assuming he is referring to the fact that he has not reviewed the case sufficiently to know if he wants to file any motions regarding the state's enhancement.
Out of an abundance of caution, I'll grant the motion to continue. I'll find good cause. I won't build error into the record and a potential 3.850 issue. It's frustrating for everyone. I'll pass the matter, given the fact that I've granted the continuance. I find good cause. I'll allow defense counsel to substitute, so current counsel will be relieved. I'll pass the case for 30 days for a pretrial in order for Mr. Jordan to receive the material from defense counsel and tell me what he thinks needs to be done. I'll set a new trial date. I'll enter specific pretrial days. I'll require the appearance of counsel live in the courtroom at each pretrial from this point forward. Not because I intend to be difficult, but I intend for conversations to take place that are hard to have by Zoom. With all of that said, I wish you well. I'll go ahead and enter the order, substituting counsel and continuing the case. The past date he's going to be back tomorrow. Let's just pass it till tomorrow then. Mr. Jordan, you can appear by video tomorrow. Your client, if that's what you choose to do, your client's on the calendar for the other matter. That way we can move the cases forward together and counsel can appear. So you'll be certainly entitled to appear by Zoom tomorrow. I look forward to seeing you. The case is passed until, give me just one more minute. You know, Mr. Murphy, what I've said is unfair to you. You came in the case recently as well. Public defender had moved to withdraw and you were appointed. So I understand the position you find yourself in, which makes me feel better about the decision I've made. I understand you couldn't be prepared in light of your own appointment. So this will be the third counsel. I'll pass the matter until August, correct that, till tomorrow, which is the 21st, 7/21, 9 o'clock, 5:08, just for pretrial. The only purpose is to keep the cases traveling together. Otherwise, I'm going to pass the case until late August. I'll see everyone back tomorrow. Thank you all.
Very good. Thank you, Your Honor.